We come together this morning to say goodbye to our colleague and friend, Lord Carnwath, to celebrate his achievements as a judge, a law commissioner and counsel, and to thank him for the important contribution that he's made both to the law and to this court in particular. I'm delighted to welcome so many of Robert's friends and family here, especially Lady Carnwath, who has been such a good friend of the justices and their spouses, as well as a great support to Robert. It's also a pleasure to welcome the Attorney General and the Solicitor General, the Lord Chief Justice and the Master of the Rolls, and many of Robert's former colleagues from this court, from the Royal Courts of Justice, from the tribunals, from the Law Commission, and from the Bar. In a moment, I'm going to invite Lord Kerr to say a few words on behalf of all the justices. But before I do so, I'd like myself to emphasize how substantial a contribution Robert has made to the law over a long career. As counsel in a number of important cases, as the author of legal textbooks, including a very useful textbook on compulsory purchase, which is how I first came across his name many years ago, as chairman of the Law Commission, as the first person to hold the position of senior president of tribunals, as the author of many important judgments, particularly in the fields of taxation, rating, planning, and administrative law more generally, and as a long-standing and indefatigable champion of the importance of environmental law. On this court in particular, he's played an important part in our discussions as an advocate of pragmatism, of the importance of legal certainty, and of an approach to public law which is based on a clear understanding of the constitutional role of the courts. In addition, Robert is almost unique on this court in being someone whose life is not dominated by work, but who manages to find time for tennis, golf, the Bach choir, music making in other forms, and above all, his family and friends. His weekly reports of his triumphs and occasional disasters on the tennis court have become a regular feature of our lives during the past 8 years, and he's even persuaded some of us to take an evening off to enjoy some of the Bach choir's performances. One of my pleasantest memories of this building will be of the evening a few years ago when, having discovered that one of our visiting Temple Bar scholars from the United States was a gifted violinist, Robert arranged with some musical friends for them all to play the Mendelssohn Octet for us. Neither will I forget the day when, in the course of discussing an appeal on which Robert and I were sitting with 3 of our colleagues, we were discussing a judgment given by the late Sir Robert McGarry. And Robert remarked that McGarry gave his wife a terrible time. He used, Robert said, to come home in the evening and have dinner with his wife, then disappear into his study for the remainder of the evening, leaving his wife to watch television on her own. The other 4 of us for whom this appalling behavior had been our daily routine for all our professional lives, looked at each other, uncertain whether our predominant feeling was one of guilt over what Robert would plainly regard as our terrible treatment of our spouses, or sheer amazement at this glimpse into the domestic life of the Carnwaths, so different from our own. We all regard Robert and Bambina with the greatest affection, and we wish them both every happiness. Lord Kerr.
Well, it's a great delight and an honor to be asked to contribute to the valedictory of my old and dear friend and colleague. When I say old, of course, I don't mean in biological years, because as you can see, he's a mere stripling, but old in the vintage of our friendship. Robert was called to the bar by Middle Temple in 1970. He practiced mainly in environmental and planning law, but he enjoyed appointments outside the narrow confines of normal self-employed practice. An example of this was that in 1980, a mere 10 years after being called to the bar, he was appointed as junior counsel to the Inland Revenue. This was not an area with which Robert was particularly familiar. He recently gave a speech on this appointment where he said, "My misgivings about applying were somewhat allayed when I learnt from the then current incumbent, Brian Davenport, that the tradition was to appoint someone who knew nothing at all about tax. I considered myself well qualified for the job." Robert stayed in that appointment until he took silk in 1985. He also served as Attorney General to His Royal Highness the Prince of Wales from 1988 to 1994, sitting on the Duchy Council and advising on a range of legal issues to do with the estate. The estate, I discovered, accounts for 0.2% of all United Kingdom land over 23 counties. So one can have a glimpse at the influence that Robert has had on our countryside. And for this work, Robert was properly appointed CVO. Alongside these appointments, a judicial career was beckoning. In 1987, Robert was appointed as an assistant recorder. In 1994, as a High Court judge in the Chancery Division, also sitting in the Administrative Division. From 1999 to 2002, chairman of the Law Commission, as Lord Reid has said, for England and Wales, before elevation to the Court of Appeal in 2002. He continued to work in legal development, and as Lord Reid has said, in November 2007, was sworn in as the first senior president of tribunals, working to lead the development of the increasingly important tribunal system. He joined the Supreme Court in April 2012, and he sat, as Lord Reid has said, on a plethora of important cases, from the constitutional, the Article 50 litigation, most notably Privacy International, in which he delivered the leading judgment, and of course the prorogation cases. But he ranged well beyond the constitutional to environmental and planning. Recently, the Queen, on the application of Samuel Smith Old Brewery against North Yorkshire County Council, and Samuels against Birmingham City Council. These have been combined with a wide array of extrajudicial speeches. Now, as Lord Reid has said, environmental law and planning remain a passion. And Robert has recently spoken about how delighted he was that the United Kingdom is going to host the 2020 United Nations Climate Change Conference, coronavirus permitting, and he has spoken about how he thinks law can help achieve environmentalist aims. He's recognized worldwide as a leading expert in the field. And as well as undertaking prodigious quantities of work in this court and producing peerless judgments at shaming speed, Robert is an enthusiastic participant in conferences throughout the world. The problem, of course, about being a world-renowned expert is that the world wants to hear you. And this circumstance presents a double-edged sword for Robert. He loves travel, and there are few corners of the globe that he has not visited. I'm sure that it's a baseless and foul rumour that while in the Court of Appeal, he had bestowed on him by colleagues the sobriquet Aerial Bob. Extensive travel can sit somewhat uncomfortably with Robert's interest in climate change. So I have decided to suggest to his many friends and admirers that as a retirement present, he and his beloved wife, Bambina, should receive an electric-powered tandem so that they can continue their extensive peregrinations in an entirely environmentally friendly and suitably elegant fashion. Now, as Lord Reid has said, Robert has, of course, a wide hinterland beyond the law. He is, as Robert has said, a noted enthusiast at tennis and golf. A retirement will present him with the opportunity to hone these, how shall I put it, burgeoning skills. He is also a gifted baritone in the Bach choir and a viola player of distinction. Well, at least in the estimation of his friends. Robert and Bambina, who complements him so perfectly and is his ideal companion, and as with all our spouses, occasional timely corrector, have a house in Italy, the country of Bambina's birth. At the time of the Article 50 case, the press evinced an unexpected interest in all of the justices' European credentials. And Robert and Bambina's house was described in one worthy newspaper as a palazzo. Robert pooh-poohs this description, but it will be, I have no doubt, a suitably elegant resting place for them both during their long and well-earned retirement. Now, one should always aspire during a eulogy such as this to reveal to the audience something unexpected about the subject of the encomium. And I'm happy to be able to make such a disclosure about Robert. Despite his seemingly thorough establishment background, Eton and Trinity, Cambridge, he is, like me, a proud man of Ulster. His family came from County Tyrone, as did my mother's. With that escutcheon, it is no surprise that he is a man of great distinction and scholarship, a true Renaissance man. And he has been a dear friend to me, and very importantly, a willing butt of my relentless teasing over the past years. I shall miss him greatly, as will all his colleagues and friends in the Supreme Court.
It's now my pleasure to invite Mr. Christopher Lockhart-Mummery, Queen's Counsel, to speak.
My Lord, I assume that I must have been selected for the honour of making this address, not by virtue of any particular legal distinction, but rather through sheer longevity. If that is right, it arises as follows. Lord Carnwath's and my paths in the law first crossed very nearly 50 years ago. On or about the 1st of October 1972, I arrived at Two Paper Buildings for my first day in chambers at the bar. The chambers were at that time nominally the chambers of Sir Derek Walker-Smith QC, but actually the chambers of Stanley Cobbett, one of the last all-powerful clerks of the old school. Stanley had assigned me to share the room of Robert Carnwath. I entered, and Robert gave me a warm raising of an eyebrow, generous, since his privacy was being shattered. We had enjoyed and were enjoying two exceptional advantages in our early careers at the bar. First, we had both been pupils of that great pupil master, Edward Cazalet, of Queen Elizabeth Building. I'm delighted on behalf of both of us that Sir Edward is in court today. Second, we were both under the tutelage of the late George Dobry QC. George was already a leading light of the planning bar in its early years, an inspiring tutor and mercurial advocate. George had, of course, recognised Robert's shining talent immediately. Each provided great mutual benefit to the other in their later careers. Robert had a stellar career, by no means only at the planning bar. His practice ranged from being an early pioneer in homelessness cases, through compulsory purchase and compensation, to, as mentioned by my lords, acting as junior counsel to the Inland Revenue. In the planning field, his many great cases included representing action and amenity groups in, for example, the case of Monaghan, seeking to prevent commercial development funding the restoration of the Royal Opera House, and even more notably, Save Britain's Heritage, seeking to save the unique collection of historic buildings at Poultry by the Bank of England. Both worthy attempts ultimately failed, but the cases remain leading authorities to this day. It's impossible in the time available to begin to do justice to the extraordinary contribution made to the development of the law by this truly Renaissance man. My lords have rightly stolen my thunder in many areas of Lord Carnwath's career, and I shall not duplicate. Before coming to his judicial career, I should briefly mention some of his published work. He wrote a very early book on the Homeless Persons Act 1977 and maintained an interest in that area, culminating, as my Lord Kerr mentioned, in the judgment of this court in Samuels in 2019. He was the joint author of one of the early textbooks on compulsory purchase, likewise maintaining an interest in that area in a number of leading judgments in that often impenetrable field. He wrote a seminal report to government on planning enforcement, arguing for greater simplicity and clarity, given effect in the statutory provisions which have applied since 1991. And so to the bench in 1994. According to Westlaw, 1,055 cases have been decided by Lord Carnwath at different levels. I cannot here attempt to do justice to his impressive contribution to the law. It will not take any student of Lord Carnwath long to realize the theme which is, in my view, the overriding characteristic of the body of his work, namely an almost relentless drive to achieve clarity and simplicity in the law where previously there has been confusion and over-complication. I single out a few examples. Before doing so, I just cannot resist the temptation to recall the occasion which also illustrates the theme I have just mentioned, when Carnwath J was presented on a Friday evening before a particularly attractive Maybank holiday with 11 lever arch files of documents on a planning case. On Tuesday morning, a judge, not in the best of humour, instructed leading counsel to reduce the volume to a mini bundle. The next day, counsel produced a single, bulging file. No, said the judge, I have a micro bundle containing the 3 short documents necessary to dispose of the case. And so to just the briefest selection of the cases. The case of E and the Home Department, when in the Court of Appeal, Lord Justice Carnwath laid down the limited criteria as to when an error of fact may constitute grounds for a public law challenge. Simple and clear guidelines which will undoubtedly stand the test of time. The lead judgment in KO Nigeria, a clutch of cases on the statutory provisions on removal and deportation and the application of Article 8 of the ECHR, which brought much needed clarity to a jumble of difficult case law on the evolving statutory provisions. The extended litigation between Client Earth and the government concerning air quality plans, self-evidently a topic of immense public interest. It is particularly ironic that if this court grants Heathrow permission to appeal against the recent Court of Appeal judgment, the views of the greatest authority on the topic will be silent. I can speak in particular of the planning cases to which he has naturally made major contributions. The themes of clarity and simplicity are especially clear in a long run of cases. I propose to single out just 3 areas. First, the European directives on environmental assessment have produced a major legal thicket of ever greater complexity and burden, or indeed litigious opportunity, for all those involved. Lord Carnwath sought to temper this process in early cases such as Bown and Jones. From the latter I quote, "With hindsight, it might have saved time if there had been an environmental assessment from the outset. However, 5 years on, it's difficult to see what practical benefit, other than that of delaying the development, will result to the claimant or anyone else from putting the application through this further procedural hoop. It needs to be borne in mind that the EIA process is intended to be an aid to efficient and inclusive decision-making in special cases, not an obstacle race." Vintage Carnwath. Second, starting in those two cases and culminating in Walton and Champion in this court, he extended the role for judicial discretion not to quash where there has been a technical legal defect, but where the aims of the directive or the statute have in substance been met. Third, over many years there has been an ever-increasing complexity in cases on the interpretation and application of planning policy. Perish the thought that the planning bar had contributed to this complexity. But if so, it had been strongly aided and abetted by judges of the High Court and even, dare I say it, the Court of Appeal. The stage was reached that one needed to take a small suitcase of authorities to even a simple planning inquiry. Lord Carnwath thought that this was largely nonsense and rode back on the trend, notably in Hopkins in this court, an approach that he and of course the courts below have followed in subsequent cases. It is fitting to end with the words of another great planning judge, Lord Bridge of Harwich, in his last ever judgment in Ruxley in 1996. "My lords, since the populist image of the geriatric judge, out of touch with the real world, is now reflected in the statutory presumption of judicial incompetence at the age of 75, this is the last time I shall speak judicially in your lordship's house. I'm happy that the occasion is one when I can agree with your lordships, still in the prime of judicial life, who demonstrate so convincingly that common sense and the common law here go hand in hand. So on behalf of the bar, I wish Lord Carnwath a long and doubtless highly productive retirement."
Lord Carnwath now has a right of reply.
Thank you, Robert. Thank you, Brian. Thank you, Christopher. You've all three of you been great friends and supporters, as have all my colleagues in this court. But I think, in a sense, Lord Bridge has said it all. I've been in the law for 50 years. I've been a judge for 25 years, which you might think is quite enough for anyone. But certainly it's been a wonderful career. It's wonderful to see so many people here who've played a major part in making that possible. I'm going to mention just a few. Edward Cazalet has been mentioned by Christopher, who has certainly started me off as my pupil master and was a perfect role model and was kind enough to believe that I could make something of this career. There was, and of course, George Dobry. I'm delighted to see Rosemary, his widow, here. He was a good mentor and friend all through my life. I'd like to mention another early influence was Derry Irvine. Sadly, he's not well and not able to be here today. I met him as his research assistant at the LSE in 1968 when we worked on the idea of a book about censorship of the press, which happily never got published. But he became a good friend and a good supporter. I didn't know then, of course, that he was going to become in due course one of the outstanding Lord Chancellors of our generation. But it was a great privilege to know him, to work with him, and to have him as a friend. I wish him all the best. Harry Wolff, I'm happy to see you here, with Marguerite, another who has given me support and advice at every stage. Among many other things, it was he who in 2005 put me in charge of the tribunal reform programme, which proved to be one of the most rewarding phases of my career, and I'm happy to see some people here from that phase. In that connection, I was very sad to hear that Andrew Leggett died a couple of weeks ago. Andrew was the author of the far-sighted report on tribunal reforms, which led to that programme and was the basis of the work which I carried on with, and our thoughts are very much with his family. But it seems particularly appropriate that his son George, who is happily here today, is going to be the one who steps into my shoes in this court. So there's a nice degree of continuity there. Finally, I must mention Lord Mackay, here happily in robust form. It was he who in 1994, as Lord Chancellor, persuaded me that I had better make the career jump to the judiciary then, before they brought in the judicial retirement age down from 75 to 70 the following year. I remember him being quite persuasive on that point, and it proved to be good advice. Thank you. Most important, of course, has been the support at every stage of Bambina, my wife. As James Mackay may remember from my swearing-in ceremony, she was not over the moon about my appointment as a judge. I've written, as she put it, I must do this, she did not want to be married to un vecchio parruccone, which you will realise means an old bigwig. Now, whether I became an old bigwig or not, others will say, but she has stuck with me every step of the way. I've also been very lucky to have the support of a large extended family. I'm delighted to see her, my sister, and a select group of my nieces and nephews. I have a lot of them, and we had to be quite selective. I happily, they are able to be here. My Italian family, sadly, of course, could not be represented. They are living in one of the worst affected parts of northern Italy. I hope some of them may be watching online. If so, our thoughts are very much with them, and vi stiamo pensando. As for the Supreme Court, I've been extraordinarily fortunate that my 8 years have coincided with an extraordinarily interesting period of development of this great new institution, and included some high-profile cases. 15 years ago, I was no great fan of the idea of a new Supreme Court, as Charlie Faulkner, also here, never ceases to remind me. Indeed, I wrote an article in 2004 saying that it was an unnecessary and expensive luxury. But I was quite wrong. Subsequent events have shown it to be a very necessary, probably inevitable development. I also think that the location and the building, after its superb conversion, could hardly be improved upon. It's a wonderful building to work in. One of the things I shall certainly miss most when I leave is my room, one of the best in London, and its view over Parliament Square, looking towards Parliament and Big Ben, and down on statues of Lincoln, Mandela, and Gandhi. It's a tremendous location, and it couldn't be better. And I pay tribute to all those involved in that achievement. I'd like to mention one person who sadly is not with us any longer, my dear friend Gary Hart, who was advisor to both Derry Irvine and Charlie Faulkner, and played a major part in locating the building and carrying through that project. I'm lucky to have served under 3 remarkable presidents, Nicholas Phillips, David Neuberger, and Brenda Hale, each with their own very distinctive qualities, which I shall not attempt to describe. I have every confidence that you, Robert, will carry on that great tradition in your particular way. They have been supported by our highly skilled and loyal staff, led by 2 strong chief executives, Jenny Rowe and Mark Ormerod, and our redoubtable registrar, Louise de Mambro, who is one of the real powers behind the scene. A special tribute also to my devoted clerks or personal assistants, John and Lorraine at the RCJ, Lorraine, happily here today, and in this court, Carmen, Isabel, and now Daniel, who, as well as his other duties, has managed today's event with great skill and sensitivity. This is not a day for controversy, but I cannot resist just a brief word about some of the recent suggestions about what might happen to this court in the future, and particularly the idea that it might come under some sort of, that appointments might come under some sort of political scrutiny. And if anyone's sort of thinking about devising such a system, I'd have two caveats. First is you need to be careful that you know what qualities you're looking for. We're not like the Supreme Court, the American Supreme Court. Very few of our cases have any real political content. Variety is the keynote of what we do, and one of the main fascinations of this place. I can illustrate that by reference to my first and my last cases here. They couldn't be more different or more esoteric. The first case I found when I came to this court after my swearing in was the first ever appeal to the Supreme Court from the Cook Islands in the Pacific. It was a Privy Council case. It involved a long-running dispute between two extended Maori families about traditional property rights. It was quite a steep learning curve, not just, I think, for me, but it was certainly of interest. The dispute had been going on for 100 years. Whether our decision solved the dispute, I don't know, but it was a sort of classic Privy Council case. At the other end of the scale, my last case, which we're hearing yesterday and today, is a case about business rates and how they apply to ATM cash machines in supermarkets. Not everyone's cup of tea, but rating, as has been mentioned, has been a special interest of mine. So I'm very grateful to Louise for having engineered it as my last case, not least because all four leading counsel are from my old chambers, landmark chambers. So it's quite an achievement, and I look forward to more of that later today. So perhaps the most important quality needed here, I think, is versatility, and my colleagues exhibit that in good measure. And second, even if one is to concentrate on more political cases, it is too easy for observers to get things wrong. Brian has mentioned the first Brexit case and the attempts of one leading newspaper to typecast us before the hearing on the as to which of us were dangerous Europhiles, most likely to, quote, thwart the will of the majority on Brexit. Now, Robert Reid and I came out as 5-star Europhiles, partly because of our links with various European judicial associations, but more curiously in my case, because I was said to be, quote, an acclaimed viola player, and a lover of European culture. Now, I certainly plead guilty to the latter. The former is perhaps more debatable. Damien Palkowski, who I've played with for many years, will be a good judge of that, and he's here today. Anyway, I'm afraid their predictions proved entirely wrong. Both Robert and I gave dissenting judgments supporting the government's position. As for their selected Eurosceptics, I think they all voted against the government. So, anyway, following our dissent, our suspect Euro credentials were forgotten by the newspaper, and Robert and I were hailed by the same paper as, quote, champions of the people. Now, I hate to disappoint readers of that paper, but believe it or not, I had supported the government, not because I felt myself to be championing the will of the people, but because I thought their arguments were right in law. Just as in the second Miller case, 3 years later, I voted against the government because I thought their arguments were wrong. And I'm quite sure all my colleagues have applied the same approach. So you're not, if someone had been vetting me for my Europhile sympathies, they might have got the answer completely wrong. But anyway, fortunately, in the second case, there was very little attention to us as individuals. All the focus was on our glamorous president and her brooch. And we all were happy to settle into the background. But I was certainly very proud to be linked to that judgment, which was a great work by Brenda and Robert particularly. Whatever its political effect, which seems to have been pretty limited, I've no doubt that it did much to cement the standing of this court and, more importantly, the reputation of this country as a world leader in the promotion and the protection of the rule of law, which is one of our most important and precious assets. So I leave the court with a great sense of pride and gratitude. I hope to spend more time after retirement on what Brian has mentioned is my particular interest in the biggest challenge of our time still, that of climate change. But for the rest of my last day, it's back to rating of ATM machines. So thank you all for coming.
The court will now adjourn.